Assembly Alejo, your next item is AB 684. Please proceed.
Mr. Chairman, and this one is where my joint author, Assemblymember Bonilla, will join me. We're here to
Absolutely.
we're here to present both AB 684, and I want to begin by stating this bill has no significant financial cost. It passed out of the Assembly on consent, and it received strong bipartisan support in the Senate Business and Professions Committee. The bill, as proposed, creates only a one-year safe harbor that would restrict the enforcement of an existing prohibition on optometrists that work within a larger retail outlet. This includes Costco, JCPenney, LensCrafters, Sam's Club, Sears Optical, Target Optical, and Walmart. This implicates thousands of hardworking optometrists and more than 2 million California consumers. This is a major issue, and while negotiations remain ongoing with regards to the underlying policy, the safe harbor legislation remains a vital piece of the overall puzzle. If it dies, then there will be a good chance that nothing will happen this year if negotiations fall through. I am sure that you're all aware that the opposition to this measure has proposed language, but their language falls short and is unacceptable to the leadership of the Assembly, the administration, and other stakeholders. This is because it did not provide any protections to the 500-plus optometrists who will lose their jobs under the model they propose. As policymakers who want to bring jobs to the state, we should be passing legislation that creates jobs, not eliminates them. And while I commend the opposition for their compromises they have made, we must have meaningful protections for these more than 500 doctors if a deal is to be had. If negotiations stall on these meaningful protections, language, thousands of optometrists and retailers they operate under are going to be enforced against merely because of their business model. This means hardworking optometrists will lose their jobs and working families will lose affordable, convenient access to vision care services. The safe harbor provisions remain the backstop if negotiations go south, and it remains the hammer to ensure that negotiations remain productive. I respectfully ask for your aye vote, and also my joint author has some comments to be made.
Assemblywoman Bonilla, you're always welcome.
Thank you very much. I just wanted to make clear that there is precedence for this bill. We worked hard to craft the safe harbor bill. In 2011, Steinberg SB 543 provided a 2-year safe harbor for physical therapists, and you can look up the language there. So there is this precedence. Now, why did we do this? It was because as we were looking at this conundrum, we realized that on top of the fact that it was putting optometrists' jobs at risk if we did not get a complete solution, also the enforcement mechanisms within DCA are not in place. Currently, if there is a complaint by a consumer, it goes to the Department of Managed Healthcare. There is no communication, I know this is hard to believe, between that Department of Managed Healthcare and the Board of Optometry. Now, the Board of Optometry is charged with enforcement. So if we're really, truly trying to seek enforcement of what is a very important policy and solve a very important problem here, and that is this whole issue around the corporate ban of medicine. The whole issue that says you shouldn't have people practicing medicine at the behest of profit or expediency or other issues. So we're trying to remain consistent and say we respect the corporate ban. We believe that the corporate ban should be in place for nurse practitioners, for midwives, and for optometrists. But we've got to have proper enforcement in place, or we're just basically deciding between businesses right now and who gets to make money in California. And I really think it's incumbent. So that was the intention of this safe harbor, was to do our work as policymakers and force a meaningful and workable solution. I like to call it, instead of just granting amnesty, we wanted a pathway for doing business in California. And we need time to create that pathway. Even if you take, even if this bill, or if this bill doesn't work and we pass something else, how is the transition going to happen? You're going to need a period of time, whether you call it safe harbor or a transition, to work this out. This bill is just that very important placeholder that says we're serious about a solution for all of those doing business here, under the provision of protecting consumers that says they shouldn't be sold, 10 pairs of glasses if they only need one. And so I believe we can achieve that with the safe harbor provision. But I would just say the important provisions here really are consistency regarding the corporate ban of medicine, allowing for a solution or transition for all stakeholders, and resolving the very important enforcement issues if we truly care about our consumer protection. Thank you very much.
Thank you. Witnesses in support.
Catherine Austin Scott, representing Lens Crafters and Eye Exam. Dr. Patel will speak to some of the issues. I just wanted to clarify that there is some concern that there's been 15 years of litigation in this space, and that my client, Lens Crafters and Eye Exam, along with others, have been shown to be illegal. That is not the case. There isn't a court case that says the model they use, which is an optician who then subleases to a Knox-Keene plan, not an optometrist directly, but a Knox-Keene plan, who then by law is allowed to employ. BMP Code Section 3109 allows them to employ a doctor. That is, no court has ever shown that to be illegal. So that seems to be a lot of the crux here, is that my client has been shown to be illegal, and the opposition will sort of confuse that issue, but no case has shown that. And what we are looking for in the discussions related to a solution is an opportunity for Dr. Patel, who will talk about the importance of her employment, to maintain that employment in a company that provides benefits and pensions and the like.
Thank you.
Hi, I'm Dr. Avni Patel. I've been with Eye Exam of California for a little over 6 years, and I ask for your support in this bill because it'll grant optometrists like me the freedom to, or the protection that we need to practice patient care without any fear of consequence. When I graduated optometry school, I chose to work in an employed model because I was coming out with an enormous debt and very little business acumen. And for me to work in a private practice or a sublease location where I just didn't know how to run a business was not ideal for me. I needed the financial security that this employed model provided me. With the employed model, I'm able to bring home a consistent salary, provide for my family without the fear, or without the, I guess, the concern of how many patients I have to see every day or how many glasses I have to sell to make ends meet. I'm able to invest in my 401 in my future, in my 401k pension options with the company that I work for. I have medical, dental, vision. I am the primary support system for my family. My husband works in a sales environment, and so this consistent financial security is very, very important for my family and for myself and many of the other doctors that I know, especially a lot of the women that are coming into optometry now, young mothers, even single fathers. I mean, I don't want to leave the dads out, but the financial security is really, really important. The benefits and the perks that this model provides us allows us to really focus on patient care above anything else without really any concern of the business side of optometry. So without this bill, my job will be threatened. I won't be able to provide for my family, and I know that many of my colleagues will be faced with the same threat to their financial standing as well. I strongly encourage that you support this bill and help us work towards a resolution.
Thank you. Additional witnesses and support.
Mr. Chairman and members, Barry Broke on behalf of Walmart and Sam's Clubs. I just want to say at the outset that we are working with the California Optometric Association and the authors on a comprehensive solution to this matter. We support a comprehensive solution to this matter this year, and a variety of the stakeholders have already come together on that solution. We think that letting this percolate in suspense would be helpful and could bring clarity to the matter over the next couple of days, because we think the best option is to solve it this year, and we're hopeful that will be the outcome of discussions taking place. Thank you.
Thank you. Additional witnesses in support. Witnesses in opposition, come forward.
Thank you, Mr. Chairman and members. Brooks Ellison on behalf of the United Nurses Associations of California, Union of Healthcare Professionals, proud member of ASME. We're very much opposed to this. We think it's unnecessary, think it's a bad precedent, and we believe if you're going to have a safe harbor, that needs to be safe for workers and it needs to be safe for consumers. And this does not have that, and we would encourage, as the last witness said, we're very, very close to a deal, and that deal has the protections in there for workers. It has the protections in there for consumers. Let's finish that deal.
Mr. Chairman, members of the committee, Terry McHale with California Optometric Association. I'll start just by saying I wish the opposition would not tell you how I will confuse you and let me confuse you on my own. First of all, let me say that this has been an expensive and long-standing process. It has been 2 decades of litigation. There's been several iterations legislatively. Millions and millions of dollars have been spent, and thousands of personal hours have been spent in negotiations. We oppose the safe harbor. We oppose the moratorium. We believe it is absolutely unnecessary. 16 months from now, the equation will not change. It has been the same issue for 20 years, and in 16 months, it will still be the same issue. We do not oppose the idea of Assemblymember Alejo carrying the bill that resolves it as long as all of the language is worked out before we get to the conclusion. Let me say simply this. When we sat down to begin this process, there were lots of people at the table, and there were lots of people on both sides of the table. And what happened initially is NAO brought together a group, and they brought together lens crafters, they brought together Costco, they brought together Walmart, they brought together NVI. 2 of them have testified today. They were opposed to the idea of, they didn't believe we could come to a resolution this year, and they wanted the safe harbor. Since then, we have invited everybody to meet to work this out. All who came to the table, all who agreed to come to the table, agreed on the language that has been given to the author and has been shared with all the stakeholders. However, one item was left open, and that item was left open because we wanted to work it out with the author, we wanted to work it out with the governor's office, we wanted to work it out with the stakeholders, and that is a reasonable, meaningful transition. We represent optometrists. We're the California Optometric Association. We want optometrists to be working. And I would say there's nothing more absurd than the idea that any group, any business doing well in California would say that if they are forced to do the leasing model, and I don't know what the number is, because first it was 200 doctors, then it's 500 doctors, then it's 1,000 doctors, that they would be unemployed, that they would be fired, that they wouldn't be able to work. First of all, the work still needs to be done. So those doctors will be working under a leasing model. The work still needs to be done. And in terms of the resolution, in terms of a meaningful transition, I would say this. We went back and researched the business that opposes it most vehemently, a business that for 20 years has not wanted to change their business model. And as they said today, what they're doing isn't illegal. Fine, keep doing what you're doing, and if it's enforced, then you'll find out if it's illegal or not. But don't say you're not doing anything illegal and then ask for a safe harbor. Of the businesses that this company runs across the country, if you pull up their business plan, who are they? They will say, come to us. There is an optometrist either in our office or next door. We are giving them a generous model inherent in the language we have given them. This can and it should be worked out this year. 16 months will not change it. So we would ask either that you vote no and reject it and let us introduce the language through another author, or that you put it on suspense and to see if we can work out something reasonable in the next couple of days. But I appreciate your patience, and thank you very much.
Cliff Burr here for the California Optometric Association also. We are strongly opposed. Senator, do you have a question for Terry?
Go ahead.
Thank you, Senator. As Terry said, we are strongly opposed to the bill in its current form. We think a moratorium makes no sense. In essence, rewards behavior that was taken that intended to circumvent the intent of California's consumer protection laws. California law has been clear on this point for well over 30 years. All the parties approached COA earlier this year, other than that one party, and said they wanted to resolve it this year. We've worked diligently. COA did not push a solution, but we were approached by the other retailers involved who sought a substantive solution this year rather than a moratorium. We have reached agreement on that solution with all those other parties who have been active in this area. There's one party that business model is not in compliance with California law, and that party has sought to overturn California law in court. They have sought to get around California law, and they continue to avoid enforcement of California law, sending a message that it's okay to deliberately circumvent California law is not appropriate, and a moratorium gains nothing in terms of a solution. A moratorium should not be imposed on the rationale that enforcement agencies are not prepared to enforce the law. Would we say that in any other area of consumer protection in California, that we should not enforce our consumer protection laws because an agency may not be geared up to enforce it when it's been the law for 30 years? I don't think so. We would urge you to either hold this bill on suspense, or as another option, as Terry has said, we have given the author of the agreement, and we are certainly open on the issue of transition. No one wants 400 optometrists laid off. We represent optometrists. That's what our association does. We are happy to work with the opponents on a transition period if necessary to ensure that that does not happen. That is the one piece that's still out there. Other than that, we have a substantive agreement on the substance and the direction of California law for the future. Thank you.
Thank you. Additional witnesses in opposition.
Savina Tagar with the Consumer Attorneys of California in opposition to the moratorium, but in support of the optometrist compromise.
Mr. Chairman and members, John Valencia here for VSP, Vision Service Plan. We're the state's largest specialized healthcare service plan delivering vision care in the state, and we've done so for over 60 years, complying with California law. Here's the curious fiscal proposition in AB 684. Save a few bucks by suspending law enforcement at the state, at the special fund, and at the local level. The Attorney General won't prosecute cases. The special funded boards, Medical Board and Board of Optometry, won't prosecute cases. And even local district attorneys in your communities will be barred from prosecuting consumer protection cases under this bill. If we can figure out who benefits from this bill, because if the proponents are right in their assertion that they're not violating California law, then who does the bill benefit? By its terms, it only benefits those that are currently engaged in prohibited business arrangements in California under California law. As a business that funds nearly 10 times the number of community-based optometrists and ophthalmologists in your districts, we oppose this measure. Thank you.
Thank you. Comments or questions from committee? Senator Nielsen.
Mr. Valencia or Mr. Kaler, one or both of you. This has been around a long time. Being around a long time, I'm kind of familiar with it. As I deliberate and consider this bill, and I have had to do it a lot, I put it in the perspective of the little office of the optometrist that I go to. Now, you note I don't have to wear glasses too often. I can usually get by when I squint, and that'll bring it in clear enough, but sometimes I use the glasses. And I view her little small practice, single person, bought the practice from another single person that we did business with for 30 years, struggling, giving up on Medi-Cal entirely. But she's very fearful of this model, if you will. It does seem to me that what we're trying to head off is a situation where the optometrist is not driven by the best interest of the vision, the health of the eyes in the individual, but rather all the stuff that can be sold. The lenses, for example. Now, her office is full of lenses. But she never talks to me about lenses until we've gone through a whole lot of tests and everything else. And then we talk about lenses. This is the danger that I feel we are going to face if we move ahead with this bill. I would certainly argue for, let's put it on hold, work on it a little bit. We can do it with an immediacy of holding till suspense or make it a 2-year bill. I don't think the world's going to fall apart. I know there's a few people out there that may be affected. I heard 150, now I hear 400. But I think we need to wax cautiously. Isn't that one of the problems, though, with the directly to the consumer? That's what I'm talking about. Their eye vision health.
In the discussions that we've had with all of the stakeholders, the number one consideration has been how do we provide the best care to the consumer? What are the protections that allow the doctor to have professional and clinical interest? And that's at the core of the agreement. You are absolutely right. Second, in terms of enforcement, during this process, the Board of Optometry submitted some language that they thought was important. It is important, and that language is incorporated also in that agreement. This bill, the moratorium, hurts consumers. It puts off an argument that has been expensive and lasted too long. And it abrogates really an extraordinary amount of work that was put together by all of those who once sat on the same side as the opposition. All of the other retailers are saying, we have a solution, let's do it now.
Thank you, Mr. Chairman.
Additional comments or questions from committee? Senator Leyva.
Thank you, Mr. Chair. Good morning, Assembly members. I just have a couple questions. I want to make sure I understand the issue. So if I go to Costco or I go to JCPenney's, the optometrist there rents space. Is that correct? Mm-hmm. Okay. And in Lens Crafters, that is not the case, correct?
Correct.
So therein lies the rub.
Correct.
Okay. And I know you said that it hasn't held up in court. No court has found Lens Crafters guilty. But if they were in compliance with the law, we probably wouldn't be here today, correct?
Correct. Well, it's been debated in the courts for about 15 years, and it's gone back and forth. And the concern is the Board of Optometry at this point could enforce against the optometrist because it is unclear and at some point drive to that decision. So the person who would be first enforced against is likely the optometrist. So that's where we get to the concern. If this bill doesn't go through or no bill goes through, then we have an access issue first and foremost in all of those locations. So it's not just the company I represent, but it's all the companies that aren't private optometry. So I hope that answers your question.
Kind of.
Okay, that's fair.
So I would never advocate for anything where anyone loses their jobs at all. However, I also think it's important that companies and corporations abide by the law. Why can Lens Crafters not abide by the model that all of these other companies?
So the concern is so the other companies are, the Walmart and Costco are aligning with COA on is a sublease model. And Lens Crafters does do that.
Which is legal?
No.
So what Costco's doing is not legal?
I gotta be really careful right now. Anything outside of private optometry is what is in debate. So I'm being real, I don't have a lawyer in the room, right? So I gotta be really careful. What is in debate is anything outside of private optometry. And that's because of the structure of the law. That said, the compromise that's being proposed by COA, Walmart, and Costco would permit subleasing. So that is where the optometrist would sublease their space to the optician would sublease their space to the optometrist. That would force my client to dismiss the 500 optometrists they currently employ through a Knox-Keene plan, because that would be the model that's on the books.
But you wouldn't have to dismiss them. Lens Crafters would just have to change their model.
They could sublease to them, but a sublease is an independent contractor or a private business the optometrist could work for, but in other states where subleasing moves forward, they oftentimes have independent contracts with this optometrists that they use. So you would sublease to one optometrist who could either employ or use other optometrists through independent contractor.
Okay.
Model.
The other issue I have or concern I have is the bill giving Lens Crafters basically a safe harbor. If this has been debated for 15 years and Lens Crafters hasn't changed their practice, why do we believe that they would do it in the next year or 16 months?
I think the idea is to continue discussions around, and what we agreed to was to continue discussions around the complexity of all this. Do I agree? I'm not sure we ever agree on employment. We haven't in 15 years, and I'm going to respect my colleagues and understand that. I think the idea is, though, is no matter what model is put out there, as the authors have articulated, it's complex and hasn't been contemplated before. So we are in support of a careful and thoughtful approach to this.
And, okay. And Senator, just to add.
Mr. Alejo, I'm going to just ask you for the sake of time if we can respond and in your closing remarks as well. So,
thank you.
Unless there's any other questions.
If I could, Mr. Chair, thank you. And this discussion, and first I want to thank Assembly Members Alejo and Bonilla for the solid interest and commitment that they've made and through Business and Professions in the committee, because this is a very complex issue. And when it first came to light for us in the Senate, there were challenges because no one was in agreement to where we go. And it seems at this point, because of the opportunity that was provided by this legislation, we're a heck of a lot closer than we were a month ago. And I think that allowing this on suspense for the couple of days will allow, I believe, for that final piece of agreement and protecting those optometrists that I think is the key, and allowing that transition period to go forward. I think, to me, that's the only piece left, because if LensCrafters is having a difficult time with the model that everyone else seems to be able to understand and work with, then that's their problem more than it is ours and everyone else's. So I look forward to the conclusion of this in the next couple of days. So I'll be supporting it.
Thank you, Senator Hill. Any additional comments or questions from committee? Seeing none, Senator Alejo and Senator Bonilla, would you like to close?
Yes, I think that Senator Hill hit the nail on the head. The Safe Harbor bill has been working. We need it to continue to work. It's going to have to contain some kind of transition timing. I want to go back to the intention of the bill, because I think it's been grossly mischaracterized as some kind of special treatment for this one company. When the Safe Harbor bill was introduced, all of the companies were in agreement they needed this. It is a work in process. People are coming together. It is about consumer protection, and to mischaracterize it as being only about business is incorrect. It really is about achieving proper enforcement, as I said, and proper consumer protection. Rushing something through in 2 weeks often doesn't give us the best outcome. If we can achieve that, more power to all the stakeholders. But without that, we need this bill, because if we don't have this bill, as stated, they are all out of compliance.
Thank you.
Thank you, Mr. Chairman and members. First of all, we came to Sacramento to help solve problems. This is one of those bills that's been deliberated on for many years, but we took this on to help hopefully solve this problem once and for all. And that's what this Safe Harbor is about. This bill came about with a lot of discussions and negotiations with the Assembly Business and Professions Committee, with the lead enforcement agency, which is Attorney General Kamala Harris's office. They came and wanted this bill to move forward, as the governor's office. It came about because everyone thought we needed more time, but what has resulted is, as a result of having the Safe Harbor bill, people have come together and worked to try to find a permanent solution. Just over the summer interim, during those 4 weeks, our office had 5 meetings with the governor's office and all the stakeholders. They were at the table. That's how serious we took it. Long meetings, but really trying to work to do a solution. But it was prompted because this bill was still moving forward. Without this bill, it's only picking winners and choosers. You have 500 optometrists who lose their jobs, and yes, the work needs to be done, but it's one model that gets favored that ends up picking that work, and I don't think that's a sound policy either. And as was stated, unlike what was stated earlier, this is not setting a precedent. Member Bonilla pointed out that in the past, on other tough, long debated issues, there has been a previous precedent with the physical therapist to do what we're asking for, and it's only for 1 year. Everyone knows it's 1 year, but yet it creates that narrow window of time for us to reach a solution. And we are on ongoing negotiations this week with the governor's office, attorney general's office, all the stakeholders to hopefully find that solution. But this needs to move forward so we can help us reach that permanent solution. And Mr. Chairman, I ask that it be taken off suspense when that is considered later this week.
Thank you. I mistakenly forgot to ask Finance if they had a file on this item.
The Department of Finance is neutral on this bill, and I need to take a little bit of a step back because of how complex the discussion has gotten. We're neutral on this bill because we believe that it makes sense to have a temporary safe harbor while these issues are figured out and the dialogue continues to take place among all of the affected parties. As the law currently stands now, we think that there is considerable dispute about who's in and who's out. The agreement aside, there are negotiations. There is sort of an agreement that would maybe bring in different players, and I'm sure everyone's attorneys are looking at that. From our perspective, it's all still in flux, and it's all still a little bit open to interpretation as the law stands now versus how the law would be under this bill, which gives basically a year for everyone to figure it out. And so we think that that makes sense for the process to continue to play out, that negotiations are moving in a consensus direction.
Thank you. And before we motion to put this item in suspense, I just want to say that I do recognize there's negotiations that are ongoing. We have gotten confirmation that the governor's office is engaged on this issue. And so I think even though it doesn't meet our cost threshold, to be able to allow this issue to continue in terms of negotiating with the interested parties. We feel that it's important to put in the suspense file to give you a couple more days to work it out. And there's nothing like having something on suspense with the deadline for Thursday to encourage people to negotiate and have a dialogue. So without objection, I'm going to move this item to the suspense files. Thank you.
Mr. Chairman. Appreciate it.
Mr. Chairman?
Senator Nielsen.
May I request, Mr. Chairman, whenever, if this bill is moved off of suspense, as with the others, but particularly this one, we'd surely like to have copies of the amendments before we sit down in the hearing.
That is going to be our goal.
Thank you, Mr. Chairman.
Thank you.